Joining me now, Natalie Jackson, co-counsel for Trayvon Martin's family. Natalie, do you know, or do any members of your firm know Mark O'Mara? Have you tried cases with Mark O'Mara or against Mark O'Mara?
I've never tried a case with Mark O'Mara or against him, but I will tell you he does have a reputation of being a very good lawyer in Central Florida. I'm here in Orlando, and I do know of him, and I do appreciate his professionalism thus far.
What did it mean to you as a lawyer, as now a friend of the family, and just as a person to hear the very first thing he said tonight, about an hour ago to Brian Williams, was he wanted to express his condolences to Trayvon Martin's family. How do you think that would be received by the family, and what did it make you feel as an attorney just to hear the other attorney say that?
As an attorney, it made me feel very proud that this case is going to be handled professionally and with humanity. And I think for the family, I haven't talked to them about his comments, but I will tell you, there is something that goes to be said, and I think it's something that we all have to learn. And expressing condolences, saying I'm sorry, and I'm not saying he said that, but there's just a human empathy and a humanness that we all have to have towards each other. And even with these people who are out there that may be upset about this decision, there still is a humanness to this, and that's that a child died.
Natalie, I want to listen to the special prosecutor explaining why she charged murder in this case.
Why your investigation led you to a second-degree murder charge?
When you have a homicide, Florida's jury instructions even say that before you can reach a degree of homicide, you have to determine whether a person has committed an excusable homicide or a justifiable homicide. All murders are homicides, but not all homicides are murders. And Florida's law clearly says that if there is the affirmative defense of, for example, excusable homicide or justifiable homicide, that should be determined before you go to the degree of the crime. That's the process this case took.
Natalie, I have to tell you, as a close watcher of this case, I was stunned today by murder 2 charges. To see something that was, by the Sanford Police Department, simply swept away, just thrown away, no charges, just no arrest, no charges. To see that taken from nothing to second-degree murder was stunning. I expected charges, but I expected them to be some level of manslaughter. How surprised were you and the Trayvon Martin legal team when you heard it was second-degree murder, the highest charge she could bring without having impaneled a grand jury?
We thought that this is the charge that she would bring. There is the lesser included of manslaughter. So in Florida, you have necessary lesser included. So the jury would get to consider that also. This is the appropriate charge, and this is the brave and the right thing to do. It gave us so much confidence in Angela Corey as a prosecutor that she's constantly just doing the right thing regardless of consequences, because anyone else would have just charged this as a manslaughter, just to appease everyone. And she did it. She did the right thing. She looked at the evidence and she came up with her charge.
Natalie Jackson, thank you very much for joining us tonight.
Thank you.
Joining me now is Kendall Coffey, a former federal prosecutor in Florida. Kendall, how surprised were you by the level of the charge?
I was surprised, I admit it. Not because I doubted at that point that there were going to be very serious charges brought. But what second-degree murder means is that he intended to do it, essentially, without premeditation, but it was intentional. And just sort of watching this from a distance, knowing that there's much that I don't know, I still honestly perceive this case to be a manslaughter. But, as was just pointed out, the jury has the ability to downgrade the charge to a form of manslaughter. And, let's face it, when prosecutors charge the most aggressive possible count that they can, it certainly improves a chance for getting a plea bargain, and it complicates the defendant's life in terms of getting bond. There's no presumption that he's entitled to get out on bond during this proceeding, and one of the early battles may be whether or not George Zimmerman is going to spend the coming months in jail, or whether there would be some alternative, such as some form of house arrest, assuming you could find a safe house with various conditions imposed, which would not be extraordinary for a case like this, where there is apparently going to be a serious defense of self-defense attempted.
This is now Angela Corey versus Mark O'Mara, and let's listen to what Mark O'Mara is up against if and when he pleads the stand your ground defense. Let's listen to what the prosecutor said about the stand your ground defense today.
If stand your ground becomes an issue, we fight it if we believe it's the right thing to do. So if it becomes an issue in this case, we will fight that affirmative defense.
Kendall, she's not going to be an easy one to get by with any defense, and I have to say that everything that you and I know from our distance from this evidence, everything about the evidence could justify some form of manslaughter charges, which I think means very clearly she knows a lot that we don't know in order to elevate that charge to murder too. She obviously has access to an autopsy report that we don't have, and all sorts of evidence that must have material in it that pushes the charge up. What would you expect, given what you know about the evidence, what would you expect would be the additional kinds of evidence you would find in her file where you would say, yep, this is second-degree murder?
Well, let me first of all pick up on your comment about Angela Corey and Mark O'Mara. We do have two very good ambassadors for the legal profession on the case, and that's a very good thing for the public as they continue to follow what is right now the most intensely watched case in the country. One of the things that I wondered about, because, you know, we hear so many things, Lawrence, that we're not really sure about. But if, for example, we heard that the individual who examined the body of Trayvon Martin saw no evidence of scuffs or injuries or scratches or anything that would have been consistent with some kind of real fisticuffs. That would be really, really important, because the essence of George Zimmerman's defense is there was this really tough fight, and he had to pull out the gun, rightly or wrongly, he thought, to save his life. I'm also fascinated, and I'm not sure that this was an element in the charging decision, but if there is going to be a forensic ability to say who was really crying for help, my goodness, if they can reliably establish that it was Trayvon Martin crying for help, that's a big factor here.
Well, Kendall, before we go, I just have to tell you, we had the funeral home director who prepared Trayvon Martin's body for burial, and he said absolutely no evidence whatsoever of any kind of struggle, just a gunshot wound, absolutely no other markings on that body. That's not courtroom evidence. They have better evidence than that with the medical examiner, and we'll be learning about that soon. Kendall Coffey, former Florida federal prosecutor, thank you very much for joining us in our breaking news coverage of this tonight.
Thanks for having me.